Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Oxford University Press and is on trade union law, employment law, whatever you'd like to call it, industrial law. The title of the book, which I think sums up where we are at the moment, is The Law of Industrial Action and Trade Union Recognition. It's now in a third edition and it comes to us, as I say, from OUP, and it's been written by some eminent people. John Bowers, Queen's Counsel, Michael Duggan, Queen's Counsel, David Reade, Queen's Counsel, and Katherine Apps. Elizabeth was the lead writer on this particular review, and the title we've given our review is Industrial Relations and the Law, the definitive text, now in a new third edition for 2019. Let's have a look at the book. There we go, it's a hardback from OUP, there we go. And it, as I say, it runs to about 400 pages. You can see from the index at the back that the index is by paragraph numbering, so you can see that from what is quite a detailed index in fact, and it starts there at the beginning, and then you can see just on the very last one there's an appendices in fact at the back. If we get into the book itself you can see the paragraph numbering at the sides. Let's go to the front of the book anyway next. There's the front page, and after the front page there's a short foreword by Mr. Justice Burton and some blurb about OUP there. And Mr. Justice Burton is President of the Employment Appeal Tribunal between 2002 and 2005 and is Chairman of the Central Arbitration Committee, the CAC. And then there's a preface by the authors setting out, in fact the book is, the actual dedication is in the preface. The book is dedicated to the memory of Lord Gladwin of Clee, and it says, who started his career as a union representative on Grimsby Docks, became a distinguished leader of the GMB and a member of both the House of Lords and the Employment Appeal Tribunal. And then you've got the contents section, which runs through quite a lot of detail in the various chapters. 20 chapters, in fact no, more than that, 24 chapters in total. Then you've got some appendices at the back, which is sample forms and precedents, and then the index. Then you've got some tables of cases running through, quite a lot of case law of course. Then the legislation, which is there, and of course some statutory instruments, mustn't forget them. Not very many statutory instruments in this book. It's a very interesting book, I have to say, as someone who's been in the trade union movement. A table of treaties and conventions, this is something that's always important these days, and codes of practice. And then we have a very useful list of abbreviations. Now I've always found in employment law that, and this sort of work, that you do need to know your abbreviations, so it's useful to have that. Then you've got the structure. You've got chapter 1. You see there's a mini index for the chapter, and then it runs through, and it starts off of course with an introduction. There is in fact in this particular book no footnoting, which is quite useful, but you do have the paragraph numbering and everything. There we go, chapter 2, you can see how the paragraph numbering runs at the side. Altogether an interesting book. So what do we say about it? Because this subject is a subject that's been with us for a long time of course, and a subject that has caused a lot of interest and concern in the past. We say this: industrial action used to be called strikes way back when, that's in the 1970s and the 1980s. And sure enough, the precursor to this new third edition of what is now a long established and definitive text was of course originally called The Modern Law of Strikes and published initially in 1987 during Margaret Thatcher's government. Now the evolution of the title is, we think, significant. It does reflect the changes that have taken place vis-à-vis trades unions in the last almost 5 decades since the 1960s and Harold Wilson's Barbara Castle's In Place of Strife. And as Mr. Justice Burton mentions in the foreword, quote, trade union recognition has once again taken central stage, adding that in his view this book contains the first detailed consideration of the new statutory scheme by reference to the cases reported on the CAC's website. And labour law is dynamic, say the 4 co-authors, as they describe the balance which the law endeavours to achieve between the right of collectively organised labour and the employer, which has been, of course, the subject of criticism from both sides of the political spectrum, and, of course, continues to this day. The book's been published by Oxford University Press, OUP, and it provides a noteworthy introduction, we think, offering the busy reader a succinct but incisive overview of the developments of labour-employment relations over the past 30 years. And in this context, the following point is made, namely that one of the most persistent causes of strikes over the years has been the request for trade union recognition, into which the law has stepped via key legislation to provide a peaceful means of settling such claims. And an even shorter summary at the end of the chapter provides a brief but hard-hitting review of the state of things in 2018. I'm recording this in 2019, just early part of 2019, but it's the state of things in 2018, supported by some revealing statistics, most indicating to a considerable degree the decline of trades union membership and therefore trades union power, although a resurgence should not be ruled out, say the authors, in the event of a Corbyn-led government. And again, that's something, of course, for the future. While it's irrefutable that the developments, good or bad, within the trades union movement are inextricably linked with politics, Parliament, of course, being the lawmaking body, the commentary in this book is objective throughout and politically neutral, covering as it does virtually all the topics relevant to this area of law. And I think it's important to make that point specifically, because there's always going to be someone who says it's politically motivated. It isn't. It's got nothing to do with it. It's a straight, very straight bat that we have from the four authors. The chapter headings themselves indicate a thorough and an authoritative examination of a formidably wide range of difficult issues. Industrial action and the individual contract of employment is one, and liability for strikes, the economic torts, are just a couple of examples. Further chapters, of course, examine trade union, or rather trade dispute immunity, picketing, unfair dismissal, employment protection rights, injunctions and more. And we would have to see what the framework looks like with some of that, obviously post-Brexit, if that happens later in 2019. 2 chapters are devoted to balloting, which is a matter of considerable controversy over the years, and I know that from my own excursions into the trade union movement when I was actually expelled because I refused to go on strike without having a proper ballot of the membership, which Mr. Scargill, of course, did not do. But I think it's important to bear that in mind, because balloting is still a controversy. And in the latter part of the book, the trades union recognition position is analysed in depth and detail over the last 3 chapters of the work. Plus, of course, there's a chapter on derecognition, if that is relevant. And I think the book is certainly distinguished by its clarity and readability. This new and updated 3rd edition of what is a classic text now, noted for its authority and reliability, is an essential tool of reference, not just for lawyers, but for the judiciary, and of course for anyone involved in trades union issues, from trades unions themselves, obviously, to employers, certainly, and to arbitrators, mediators and conciliators, the old ACAS structure. Finally, let me say this, indeed the researchers in any sphere, we think, will find very useful the extensive table of cases, quite detailed, the legislation, the statutory instruments, treaties and conventions, and the codes of practice. And the table of contents at the back is fortunately very detailed. The table of contents at the front, rather, is very detailed, as is the index at the back of the book. Also, of course, do note the appendix, which contains some sample forms and precedents. And the book is up to date as at the 10th of October 2018, and the date of the publication of the 3rd edition is given as the 20th of February 2019. Let's just have one last look at the book. There it is, the spine. There's nothing on the back. It's an interesting book, as I say, just opening it. Picketing, criminal offences and statutory restrictions. That's just the halfway point, if you like, through the book. You can see the index, the actual introduction and the paragraph numbering, and you can see it's a lot of detail. And it sets out, as I said, I think it's a very neutral book, and it sets out very well what the law is as it stands at the moment. Now, it's quite possible that the law may change again, as has been indicated, but at the moment this is where we are in 2019, and I would not expect any dramatic changes until we see what happens. The next election is 2022, so it's some way off. So this is a very live book. Thank you to all the authors and to OUP for what I consider to be a first-class book. Thank you. Bye-bye.